a major category of contemporary art and set a precedent for affording such artists moral rights. Meanwhile, Banksy continued to grab headlines. In 2019, he famously shredded his balloon girl the minute the gavel landed at a Sotheby's auction. And in 2019, the year his devolved parliament sold for 9.9 million British pounds, he opened a pop-up shop for the purpose of securing trademark rights in his name so he could prevent others from merchandising his art. Banksy's art and antics persistently confront issues of ownership and rights. I'm delighted to introduce our panel of speakers to you. Given the virtual nature of the conference, we took advantage of the opportunity to bring you voices that wouldn't ordinarily be heard in the ALS annual meeting. So I'm going to briefly introduce the speakers in order of their presentations. I'm going to be very brief. All of their fuller bios are online, and I know that you are anxious to hear from them and see their beautiful slides. So first, we have Marie-Cécile Flajoul. She is the co-founder of 5 Points Creates and the curator of the Museum of Street Art. A longtime spokeswoman and advocate for 5 Points, she selected artists and curated the art for the project. She has received attention and praise for her curation, as well as awards and board memberships for her art activism and advocacy for public art. Next, we'll hear from Cathay Smith, who is an associate professor at the University of Montana Blewett School of Law, where she teaches intellectual property, and art and cultural property law. Her scholarship focuses on trademark and copyright law and theory and their intersection with art, culture, and society. Next, we'll hear from Katya Asaf, who is an assistant professor of law at the Hebrew University of Jerusalem. This year, she's a fellow at the Institute of Advanced Study in Berlin. She specializes in intellectual property and writes about graffiti and the regulation of urban space. Katya is joined by her co-author, Tim Schnettguk, who is a professional photographer based in Berlin. He's a connoisseur of vandalism, specializing in portraits and documenting graffiti on trains. And finally, we'll hear from Eric Bonadio, reader in intellectual property law at City University of London. His research focuses on copyright protection of non-conventional forms of expression, and he's a member of the advisory board of New Art Journal, which publishes on a range of topics relating to street art practice and urban art cultures. Each speaker will make a short presentation, which we will follow with a panel-wide discussion, and we will end finally with questions and answers from the audience. So you should feel free to engage with the speakers by posting your questions. So with that, I'm very excited to turn this over to our first speaker, Marie.
Thank you so much. I am delighted to be here. As a non-lawyer, I'm probably one of the only panelists. Thank you, Tim, for being here too. So I'm a little less lonely. Thank you for the introduction. For the past 7 years, I've been actively involved in what is known now as a 5 Points case. And today my goal is kind of to quickly, but hopefully efficiently, kind of give the premises of the case and maybe clarify certain perception or misconception about the case. And I'm doing so to pay tribute, obviously, to the 21 artists, but also to give a better understanding of what the case was really about. So 5 Points in context, you spoke a little bit on 5 Points, Christine, really well. Pretty much if you go back to early 2000 in New York, the window theory was still in effect. Artists could no longer really paint on trains. And a new wave, a new generation of artists were still working illegally, but were trying to push their craft. And they wanted to do bigger, larger, better, more detailed murals. Jonathan Cohen Mears One, the founder of 5 Points, had been writing since the early 90s and would practice on a warehouse located in Long Island City, which at the time was known as the Fun Factory. It was started by Graffiti Exterminator, which was a company which would clean up graffiti and charge building owners. Long Island City, if you're not familiar with New York, was extremely industrial, warehouses, and the actual building was named the Neptune Meter Factory. So it was industrial, it was desolated. Jonathan Cohen Mears pretty much made a verbal deal with the owner. He was painting on the building and decided to take the program over. What it meant was that he was running the program for free for over 11 years. And his concept and idea was to cater to his fellow artists. He knew that when he wanted to push and develop a new technique, whether it was in lettering, characters, full production, it was difficult to find a large wall, but also to have the time to do so, because you cannot do that illegally, or it's very challenging. So it was kind of a vision he had, and it was allowed and encouraged by the owner of the building. It was the same owner from 1973 when he purchased the warehouse until the whitewash, the infamous whitewash. By 2004, so 2 years after he took over, the New York Times named the location the first outdoor graffiti museum, and called Mears one of the first graffiti curator for his peer. So the goal was really to push. So this is pretty much what you would see in Long Island City on exiting the seventh line in Long Island City. Jerry Wolkoff was the owner of the building, as I said previously. It was a handshake. Nothing was, I know lawyers love paper. This was an agreement. It was a verbal agreement. Yet the agreement and the terms were constantly confirmed and affirmed in press interviews as early as 2004, as I mentioned in the New York Times. In 2004, Mears formed a 501c3 under the name 5 Points. 5 Points Aerosol Art Center. He was a head of the non-for-profit. And it was named 5 Points because his goal was to have the 5 boroughs coming as one. And then later, it was also the 5 elements of hip hop coming as one in a venue where every art form could be expressed. And everything was going fine. The owner was happy. His building looked better and better, which means the community was not complaining. And very quickly and very rapidly, it became obviously an art hub for the artists, but also it became an artist attraction. By the time 5 Points was whitewashed in 2013, you could see up to 20 tour bus coming daily to look at the artwork. It almost became a problem because artists wanted to paint on the roof more than street level because they were bothered by photographers, tourists, tour guides asking questions. So the relationship was very limited. There were very little interaction between the owner of the building and the artist, and it was really on Mears to run the program, accommodate artists, source ladders, scaffold, supplies, and make sure that everything ran smoothly. Everybody could paint, but there were very simple set of rules. You had to request a spot from Mears One, so you couldn't just walk up to the building and paint. You had to submit a sketch, especially if you were an international artist or a beginner, and you were given a spot by Mears. And you had from a few hours if you wanted, to a full weekend, to a full week if you needed, depending on the size of the production. And incredibly enough, in a city like New York, and starting in the early 2000s, there were no problem of ragging. Ragging in graffiti is a term of someone going over someone illegally. Because Mears One was an artist, fellow artists respected him, the culture respected the location, and so there were never any problem of art being disrespected or damaged. The longevity of the wall was determined by the quality of the artwork. Sometimes an artist can have an off day and they would come and expect to do a beautiful piece, and it was an off day, and they would be the first one to tell me, oh my God, I really didn't do a good job. Please go over this. I'm not proud of it, but thank you for the spot. And also it was an old building, built in the early 1900s with very little maintenance. So as early as 2008, we started building our own walls, framing, applying plywood to give better canvas to the artist. Again, all funded by Mears and the volunteers. G&M Realty, so the real estate entity, and Jerry Wolkoff were able to generate revenue. The same way the building got fame with the artist community, it became a prime location for photo shoot, motion pictures, and he was getting good revenue from renting the location for such shoot. So it was a win-win situation in both cases, and everything was going fairly well, again, with very limited interaction between the owner and between the artist community and Mears one. Proud to say that for 11 years, we never applied for a grant. We never asked for any government money, and we ran it organically and self-funded everything we did. So Mears, just quickly, born in the South Bronx, raised in Queens, started painting in the early 90s illegally. The light bulb you see is his bright idea. This was the first character he started doing when he was 13. And by taking on 5 points in 202, he, in a way, almost put his career on pause, because 5 points was a priority. 5 points was his masterpiece. And 5 points was, for him, a way to showcase the culture and show the craft. So very early on, he was an activist for the art form and not solely for the illegal aspect of the art form. So this I kind of touch on. So this is by Mr. Blob. And Mr. Blob is an artist from Milan, Italy, who painted in February of 2012. His artwork was whitewash. And this is a perfect introduction to what really, I think, interests you, which is the legal battle and the premises of VARA being invoked by the artist. So this is all spray paint or aerosol. It was painted in Milan in 2014 during Meeting of Style. And you see 5 points looking like a tank. You see me on top of the cannon with a megaphone, screaming at suits, and you see every element of hip hop. So you see Mears one doing a light bulb, you see a break dancer on the hand, you see MCs and big boxers and DJs, and it's up to you to determine who the suits are. I will not comment on that. So I just wanted, so you kind of get an idea of what was whitewashed. I picked 5 pieces for 5 points. You have Mr. Plume's a face that's very Fauvism. This was done in 2012. He's an artist from France. In the middle, you have James Cochran, Jimmy C. from Australia, lived in London, is now based in Paris. The original piece of Mr. Blob from Milan. Two Fly Love Warrior. She's based in Ecuador, born and raised in New York. And a Wild Style by Mears one. I'm on the, sorry, I think I'm on the wrong, I'm on the wrong presentation. Give me a second. I apologize. Okay. I apologize. Give me a second. I have a glitch here.
Not to add too much pressure, Marie, yeah, but your time is coming to a close in addition.
Okay, so you know what? I'm going to do it without a slide, and that's fine. Okay. So pretty much in 2013, the landlord applied in front of the community board for a hearing asking for a variance. So he wanted to develop, he was a real estate developer, and he decided to develop his property. We attended every meeting in the community as residents of the community, and the artists were concerned, and they were concerned about having a chance to preserve and save the artwork because it was a large collection. So every meeting between May and September artists, community activists attended. City Council gave the variance to the landlord in October of 2013 and gave him the get-go to develop and build 2 large towers instead of the artwork. In the meantime, an attorney approached us and told us about VARA, Visual Artists' Rights Act. So by October, when the variance was given, artists got together, organized with this attorney, and invoked their VARA rights. It led to a request for injunction in federal court, Southern District of Brooklyn, in front of Judge Block. And he listened to the artists and experts for 4 days, and the landlord and his attorneys, and was really puzzled. And that's what's really important about the case, is that at the end of the injunction, or the request of injunction, the landlord and property rights won. The judge said, I cannot side with the artist. I'm sympathetic. I think the art is extremely interesting, but I cannot take away the property right of this developer. And we were waiting for the written decision for this to decide the next step, if any. And in the middle of the night, November 18th, 2013, the landlord hired a team of workers, and New York woke up November 19th to the entire building whitewashed, poorly whitewashed. So by his action, and by deciding to whitewash, when the judge had already sided with him, he then created what followed, which was trial with a jury. Had he just sent us a 90 days notice after the judge decision saying in 90 days, the building may or may not go down, but in 90 days, you have no access and you cannot try or attempt to preserve, there would have been no trial. So the trial started in November 2017. It lasted for a month. 21 artists were involved in a case, 49 pieces. Artists testified via Skype from Chile and Brazil because they couldn't come in the country. And we went with a jury. And an interesting fact is 4 days before the end of the trial, artists decided to go back with the judge. And the defense had no position. And the reason why is we were every day in a courtroom, and VARA is a complicated law. And we could tell that the stature concept was complicated. The damages, we could see we were losing them. And it was a long trial, to be honest, with entertaining testimony sometimes from the artists, but also fairly obscure testimony from some of the experts. And the last day was Jerry Wolkoff's testimony. That's the only day he came into court. He testified. And then in 3 days, the jury came back. And we were happy to have gone with a judge because it was very clear with a jury decision, even though it was pro-artist, that they were confused and did not really understand what VARA was about and how you determine stature. So the judge then took over, and in February, as you mentioned, we got the decision from the judge, which was to award $150,000, which is a maximum amount you can give per mural, to 45 out of the 48 pieces in the case. And the 3 pieces which were not awarded were because they were seasonal or painted after September 15th. So he felt artists knew they were taking a chance. Appeal Second Circuit, an attempt to appeal at the Supreme Court. And as you all know, we have officially won as of October after 7 years. I just want to finish by saying that some of the challenges for such a case, which can be pertinent to lawyers, is it's very difficult to have 21 artists in a case. It took a huge amount of work from our law firm, from my end, to coordinate, to get evidence. Discovery, I think, was the most traumatic for all of them. Every text, every email, every phone conversation could be subpoenaed at one point or another. So I think even though no one entered this case for financial gain, it was an attempt to preserve and save the art. The legacy is hopefully a recognition of moral rights in this country, and especially for this art form. And then it has created a strong communication with a lot of landowners, developers, and an understanding that graffiti and street art can be preserved, can be moved, and can be reinstalled and repurposed. So thank you so much. Sorry about the glitch with the presentation.
Wonderful. Thank you so much, Marie. And now we'll move to Cathay.
Okay, so thank you so much to Christine in the section on art law. Can everyone see the slides? Yes. For hosting the session and putting together such a wonderful panel of art lovers. So today, to sort of speak to and reflect on the theme of this year's AALS meeting, I want to talk about the power of street art, the power and the destruction of street art, and how street art can challenge our understandings of common legal doctrines. So art can be more expressive than words, right? It can speak louder than words. It can communicate messages across different languages, cultures, socioeconomic barriers, especially when that art is public art. So in other words, art that is created on and for the streets, for the public to view and for the public to interact with. So in this way, street art is democratizing form of art, right? It's not locked away in someone's private vault. It's not adorned on the walls of an art institution. And street art doesn't require someone, for instance, to pay a $20 admission fee just to see. It's not exclusive. And it's often created to express a message that directly speaks to the public. Sometimes this message can be commentary, criticism, or satire of current social, cultural, or political events. It can comment on inequality. It can commemorate fallen heroes. It can praise and can also criticize, and it's almost always timely and relevant. Street art also has and continues to challenge our understanding of legal doctrine, such as property law, right? How do we compare a property owner's right to destroy versus a community's right to preserve, or in the case of moral rights, right, an artist's right to preserve? And it can also challenge many of the copyright doctrines that we may take for granted. So for instance, we know that copyright protects original works of authorship fixed in a tangible medium. But what is original? Street art can challenge our understanding of or our ability to judge what is an original work of art. Does a tag or writing on a wall meet copyright's originality standard? And what if that tag is multiplied across an entire wall? Street art challenges us to judge art and to draw boundaries between expression that may not be original enough to warrant copyright protection from expression that meets copyright's modicum of creativity. Street art can also challenge the idea of fixation, right? Street art, by its nature, is ephemeral. But fixation for copyright merely requires that an expression be fixed in a tangible medium for more than a transitory duration. Creating a chalk painting, for instance, on the sidewalk probably meets fixation, even if rain destroys it a couple minutes later. But what about creating art in the sand on the beach at low tide, or creating ice sculptures that are meant to melt to deliver their expression? Or, creating art by beaming light onto a building in downtown Chicago. Street art and public art can also teach or even challenge our understanding of non-infringing, de minimis use, or even fair use. For instance, street art appears briefly blurred in the background of a scene of an original HBO TV show, maybe non-infringing de minimis use, but what about street art that briefly appears in a video, but is purposefully featured in the propaganda film in order to make a statement? And are the rules for fair use the same for unauthorized uses of street art that may have been created for and on the streets? In addition to copyright law, some of the most recent notable disputes involving street art and public art have been based upon the Federal Visual Artists' Rights Act, which we've also already heard a little bit about this morning, which is the U.S.'s federal law protecting the moral rights of artists. Disputes involving street art continue to mold the application of VERA. For instance, before street art can even be protected under VERA, it has to meet the statutory definition of a work of visual art. But what is a work of visual art? We've learned over the past few years through examples of street art and public art cases that apparently a living landscape garden is not a work of visual art, nor a giant walk-through sculpture created by employees, or reconfiguration of a school bus into a 16th century Spanish galleon. But what about a wall of cheese built next to the US-Mexico border? Or a collection of hanging red tote bags? Are those works of visual art under the statute? We're probably going to find out soon. Additionally, one of the moral rights that artists in the US have, we know under the Visual Artists' Rights Act, is the right to prevent the destruction of a work of recognized stature. But the Act doesn't define what that means. So what is a work of recognized stature? Right? How do litigants prove that works, which maybe just 20 years ago might have been called vandalism, achieve recognized stature so much so to prevent its destruction by the legal owner of a tangible piece of art? And so I think a new challenge that we are facing today and over the past few years is what about art that offends or harms or perpetuates negative stereotypes? And who gets to decide what art to preserve, how that art is preserved, and what is destroyed? Right. So over the past year, we have become more and more aware of our public spaces. We are questioning our public monuments. We are calling for the decolonization of our public spaces, public art that may be offensive, or public art and street art that fails to reflect the progress that we have made as a society, or that no longer represents the morals or beliefs of the public or the community surrounding it. And just quick warning, the next slide does include images that some of you might find offensive. And when I talk about these pieces of public art and street art, I'm not just talking about Confederate monuments, right, that are getting a lot of attention in the news right now, that sometimes may stand as the most prominent art in a community. But there are works that, whether intentionally or unintentionally, are considered offensive today. For instance, public art that may have been created to shed light on the ugly truth of national heroes like George Washington, or to celebrate the end of slavery in a country, or to remind us of the inhumanity of slavery and commemorate a state's role in the Underground Railroad, to educate us about past atrocities against Indigenous communities. These artworks and artists may have had good intentions when they created the work or not, but these works, in our eyes today at least, can appear insensitive, can appear derogatory, racist in their characterizations of people and communities that continue to perpetrate harmful impacts. And so what do we do with these works? Should we preserve public art that, when we look at today, we understand that these works don't represent what we as a progressive society want to commemorate or to celebrate? And so today I want to end by posing that there is power in art, especially public art, especially street art, that creates a dialogue with the public on the streets. But there's also power in the destruction of art. And the destruction of art can create important and often necessary public dialogue. It can express important political, social, or artistic messages that maybe can only be expressed through this conversation about, or the ultimate destruction of, a piece of public art. And that destruction can make an even more powerful statement sometimes than the original artwork itself. And so in addition to focusing on this argument of preservation, perhaps we can reflect on what and how we want to commemorate and what we want to commemorate, and whether we can commemorate and celebrate certain ideals through the destruction, the intentional and expressive destruction of street art. So in other words, in certain instances, maybe the expressive destruction of public art and street art should be celebrated just as much as we celebrate the preservation of works of art. Thank you.
Cool. Okay, now we'll move to Katja and Tim.
Okay, we will be talking about our essay, Reading the Illegible, Can Law Understand Graffiti? Our essay offers a novel perspective on graffiti. As we all know, social responses to graffiti are highly ambivalent. Although graffiti writers are most commonly perceived as vandals and hooligans, some forms of graffiti are recognized as valuable street art. Reflecting this uneven attitude, legal responses to graffiti greatly vary, from criminal sanctions to copyright protection, and even recognition as cultural heritage. Similarly, scholars have made various suggestions regarding the legal regulation of graffiti, ranging from toughening the criminal sanctions to providing more legalized spaces and art programs for the artists. Despite this diversity, all the responses bear one common trait. They all take an external look at graffiti. They all treat it as a certain phenomenon, one that should either be suppressed, encouraged, or appropriately manipulated. Our essay takes an alternative perspective on graffiti, proposing to attend to its message and respond to it with an adequate legal change. Indeed, several scholars suggested that all graffiti communicates one common message. This message reveals and challenges the hegemonic power of property, commerce, and politics that dominate our visual environment. It also opposes the isolation of art from everyday life and rejects the authority of art institutions to define what real art is. Instead of suppressing or manipulating graffiti, we propose to answer this message with redefining the boundaries of physical property so as to restrict owners' control of the surfaces that shape our urban landscape.
These surfaces, walls, bridges, trains, will then be used as a medium of free visual expression, as a public forum in its most classical sense, a place of discussion, opinion exchange, and purely aesthetic expression. It will grant city residents the right to create their own urban landscape as a constantly evolving collage of their expressions. This idea might sound somewhat radical. If we take the example of a building, the walls belong to its owner. How can they possibly be expropriated? Yet, property right is actually a bundle of privileges established by law. The precise content of this bundle changes from time to time, often in response to social pressures. Some walls are indeed the outer side of buildings belonging to someone. As such, it may seem natural to perceive them as part of the owner's property. Nonetheless, our public space is contained between these multiple surfaces. Buildings' exteriors are the inner walls of the public sphere, public spaces we all share. In this sense, the public and the property owner are similar to neighbors living on opposite sides of the same wall. From this perspective, the question of who should determine the appearance of city wall, those who live on one side or those who spend their time on the other, may seem less obvious. Moreover, under current legal regimes, walls already do not fully belong to their owners. Their appearance is subject to various urban regulations. For example, such regulations may dictate the color and the design of the outer walls. Thus, an owner's right to control the appearance of outer walls is already significantly restricted. It is municipal officials who largely exercise this right. And since the latter represent the public, it can be further argued that the public already owns a large portion of the right to determine the appearance of city walls. Hence, to a significant extent, the proposed legal change would occur between different regimes of public ownership, rather than between private and public ownership regimes. In other words, we suggest that the public should determine the appearance of city walls in a decentralized process emerging from multiple individual initiatives, rather than in a centralized political process. Providing a public forum where all voices will have an equal opportunity to be heard has the potential to make social discourses more inclusive and egalitarian. This is a chance to redefine cities as sites of social debates and artistic experiments. Instead of directing people to passive consumptions as they do now, public spaces will invite them to share their visions and concerns. As the Black Lives Matter movement shows, it may take much too long for injustices to become visible. Allowing all people, rich or poor, black or white, to express themselves on city surfaces can make society more attentive to such injustices and accelerate changes that will remedy them. We believe that allowing free writing and painting on urban surfaces will promote understanding between social groups. The current proliferation of social media, whose filter bubbles direct users only to messages matching their previous views, leads to polarization and reinforces prejudices. By contrast, messages on a city wall or on a train will be seen by all passerby, regardless of their views. This would expose everyone to a plethora of social voices, raising people's awareness to other social groups and promoting mutual understanding. Thanks for your attention.
Thank you.
Great. And now we'll hear from Enrico.
Stop share.
Okay. Oh, I'm gonna. A second. I'm gonna share. Can you see the slide? No. Can you see the slide now? Okay, perfect. Okay, thanks so much for inviting me to this panel today. As you know, I will be focusing on street art and copyright. I have made recently research, not only legal research but ethnographic research on these issues. So I have interviewed many street artists and graffiti writers, including mayors, years ago in Mary's house in
Enrico, I think we're not seeing your slides. At least I'm not seeing that.
Strange. Let me check.
After you choose a share screen,
now
click on the slide, exactly. And
now
then
you can see them.
presenters mode.
Now it's okay. Great. Okay, so I've done research, both legal and ethnographic research. So I was interested and asked many questions to both writers and street artists. What do they think about copyright? Would you like to protect your artwork by possibly taking legal action against corporate appropriation or against destruction by property owners? So I have heard many opinions in this specific regard. Just want to do a distinction at the beginning. We need to distinguish two different forms of art here. On the one hand is graffiti writing, right? Which is lettering, writing names on walls and trains, subways back in the days. So writers do that. Writers do write their name to get up, right? And then, of course, there is a street art, more figurative forms of art. The line distinguishing street art and graffiti writing is not so clear. Sometimes it's blurred in the sense that there are graffiti writers also painting figurative stuff, and there are street artists also, painting letters. But it's important to take into account this difference between two subcultures at the end of the day. So I want to start with the most hated graffiti artwork, the tag. People hate tags, the normal people. I mean, my grandmother, if I ask my grandmother, do you like this? She will ask, but that's pollution, that's visual pollution, that's not art. And I try to explain to my grandmother, look, grandma, you have to look more carefully, because graffiti writers, it takes years for them to develop their writing style. In order to be able to write a good tag, to paint a good tag, it takes years and years of practice. So I interviewed, when I was in New York, Mary, I interviewed Easy. You may know Easy is a graffiti writer from New York, and is quite well known. He paints on, his tag on shop shutter, but he also paints his tag on canvases. So on the left, we may say, on the left, it's visual pollution, and on the right, it's art. But it's the same thing. It's the same thing. So be careful, because our assessment of, for example, the originality requirement in copyright law might be corrupted, might be biased, in the sense that on the left, we may say, look, this tag is not original, it's just rubbish. But on the right, we say, that's good, that's art. But it's the same thing at the end of the day. So be careful, because I haven't found in any copyright statutes around the world a provision which tells me that I have to take into account the support upon which the artwork is placed. So the different support could be a rubbish bin, could be a shop shutter. The support upon which the tag is painted might corrupt our assessment of originality, and that would be wrong in my opinion. Another important aspect: illegality. 5 points was legal, was authorized, so we don't really ask these questions. But we know that much street art, much graffiti, especially back in the days, but also now, is still made illegally. Is copyright available, and are enforcement rights available? Well, in some countries, this is still a gray area of the law. In the US, we have some judges in the Villa case that they have invoked the unclean hands doctrine. So a graffiti writer, a street artist who paints illegally cannot ask the judge to be granted injunctions or damages because his or her hands are dirty, are not clean. Well, I'm not a fan of this unclean hands doctrine because, in my opinion, it ends up legitimizing co-option instead of the very creation of the artwork. Because the unclean hands doctrine has been invoked by defendants, corporations, which have misappropriated the art. I'm talking about H&M in this case. H&M actually here started the legal action against Reebok. They say, look, I can steal the artwork because the artwork had been painted illegally by Reebok in Williamsburg, right? In Brooklyn. And also the same was for Moschino, the Italian fashion company. They said, look, I can do whatever I want here because the vandal was a vandal. He committed a crime. So this result, the unclean hands doctrine, leads, in my opinion, to an absurd result, an unfair result, to reward the appropriators, the misappropriators of illegal street art. That's why I'm not a fan of the unclean hands doctrine as applied to graffiti, illegal graffiti. Another point: much graffiti and street art is anti-establishment. Writers, street artists, they want to fight the government, they want to fight the system, they convey anti-establishment messages. I have read somewhere that this feature of the movement stands in the way of copyright. Well, I think it's a very weak argument because we have fine artists that are very anti-establishment, and nobody doubts about the protection of anti-establishment fine art. Copyright is flexible. You want to sell out? Copyright is there to help you selling out, to help you doing merchandising. But copyright is also helpful if you want to keep the message anti-establishment. Copyright is neutral and flexible. For example, in those legal actions started by writers against corporations, well, these writers, these artists, what I have asked the judge is to issue an injunction against the corporation in order not to be associated with profit-oriented messages. So they used copyright law to keep it real, to keep the message anti-establishment. Copyright is an instrument, is a legal tool which can be used for whatever purposes. To sell out, if you want to sell out. To keep it real, if you want to keep it real, and so on and so forth. Let me then focus on the social norms, because it's a fact that within these communities, writers and artists, street artists, they also rely on street justice, social norms. Not only copyright, of course, not all love copyright, of course, also in my interviews, this came out. And so they, for example, if someone copies their mural, what they do is to take an action. They don't file a legal action in court. Of course, they paint over, for example, they paint over the artist who has copied, or they use gossip on social media. Right? They go to social media and start shaming the artist who has copied. So I want to introduce you to a feud, to a fight between two artists, Banksy, the most famous street artist in the world, and Robbo. Robbo was a writer in London, one of the first writers in the 80s. He painted this mural back in the 80s, one of the first. It lasted for many years. Then Banksy came and did this. Well, this is very bad in the graffiti communities because it's a sort of appropriation of mutilation. Then Robbo replied by saying, I am the king. Then Banksy came back by saying, look, Banksy came back by saying, look, Robbo, you don't have to do that because I'm replying to you. And then Robbo again, they started a kind of dialogue between themselves like that. And then the council came, painted over. Then Robbo came by saying, your career is dead, Banksy. And then the council again came. Then Banksy painted this. And what happened is Robbo then unfortunately fell into a coma. And Banksy, the old enemy, paid him a tribute by painting this mural. And then, unfortunately, Robbo died as a consequence of this incident, of this domestic. And his team painted again the original mural. Well, what can we infer from this? This is a dialogue, a conversation between artists, between writers. It is also a way of resolving disputes, right? Social norms here work very well. So my point is that copyright is increasingly used by street artists and writers, 5 points case, and many other cases on exploitation of economic rights. And social norms also work very well. So I see, from my perspective, I see copyright and social norms as being complementary. So copyright is increasingly useful and looked for by writers and artists, especially when money is involved, especially for the economic rights. Social norms are instead very fit to regulate different aspects of graffiti creativity. So, is copyright for losers, as Banksy famously said in 2005 in his book Wall and Peace? Well, it's his opinion. Banksy thinks, or used to think, that copyright was for users. From my ethnographic research, I have witnessed a growing interest in copyright and moral rights. And going back to Banksy, well, it seems that Banksy changed his mind because in the last few years, he started legal action relying on trademarks, mainly, not on copyright, mainly on trademarks. Why? Probably the decisions to rely on trademark law against fake merchandising is due to the fact that these trademark actions have been started by pest control, which is his association, his company, and he remains behind the scene. And the owner of the registrations of these trademarks is the association. But when it comes to copyright, probably he doesn't want to take action even through his association because you would need to reveal his identity. And of course, revealing his identity would detract value from his art. So he doesn't want to do that. So I thank you for your attention. I hope to have respected my time, Christine, and I'm open to questions.
Wonderful. Thank you. Thank you all so much. Those were incredible presentations, so much insight and so much amazing slides that I enjoyed. Well, we don't have too much time before we turn to the audience. So I guess I just want to reflect on some of the high points that I think came out that were so interesting in the ways that your presentations spoke to one another and some of the valuable and unique insights that you brought out. I was just so taken with Marie's description of having 21 street artists in the case. We think about a law, we think about the rights of artists, we think about rights protecting artists. I don't think we think so practically about how artists interact with the law, as that example brought out. And then Cathay really was teasing out all of the legal constructs which we have to contend with, originality, fixation, work made for hire, recognized stature. And I think that led directly into Tim's and Katya's point about the messages and the dialogue in street art, and how the message is I think it was Enrico's words, kind of anti-establishment, the challenging of definitions of art, the challenging of, corporate ownership, commerce. And then we lead to the points teased out by Enrico about whether artists can really co-opt these legal norms, or whether they might be instead co-opted by them the more they engage with them. So in the time before we go to audience questions, I guess I would just like to give you all a chance to make another comment after having heard each other's presentations. And I think maybe we'll just go in the same order, just take a few minutes because we don't have much time. So if you want to speak to any of that, or if you want to follow up to anything that was said, I'll start with you, Marie.
Thank you. Actually, Katya and team presentation really echoed with me and the definition of who owns the wall. And obviously in Europe, historic district and landmarking is even more active. I wish that concept had been in our mind even when we were trying to get the building landmark prior to invoking VARA, because that same definition, that same concept authorized the city at the beginning of, before the birth of 5 points, to fine the landlord because illegal graph was on his wall. So he was forced by the city to clean up. And now today, the Germania Bank building in the Bowery is a landmark building and was sold to Abbey Rosen, a developer. And it's a famous building. It's covered in graph, and Basquiat used to hang out. And with Historic District Council, which I'm on the board of, we protected and landmarked an illegal block letter by Nex simply because the building is landmarked. So we were able to dictate and tell the owner, you cannot clean up and you have to preserve it because Nex is no longer with us. So it was his last piece. And he agreed, but he was forced by landmarking on a building he owns, so walls he owns, an illegal piece. So to me, that was one, all presentation were mind-boggling, but that concept of who owns the wall and challenging the property concept to me was, something to think about in the future.
Kathy?
I agree that I was just I'm inspired by all of the presentations, and this has been an awesome panel. And since I can only pick one, Enrico, when you I really liked your challenge of originality, especially when you showed the slide of a tag on a wall or a door, and then show the same exact thing on a canvas, right? Originality is not really supposed to be based upon the tangible medium in which an artwork is created. And yet, that showing those two pieces can really help challenge our understanding of originality and what we are influenced by, right? The medium in which we are influenced by, when we're really only supposed to be looking at the artwork itself. So I thought that was really, really effective.
Katya and Tim?
Well, Enrico, I really liked how you mentioned social norms in combination with copyright. And something I was thinking about was coming up with some kind of Creative Commons license for non-commercial purposes for graffiti. So you can kind of regard it as a gift to the public, but you can't use it for advertising without talking to the artist first.
You're muted. Enrico, we cannot hear you.
Absolutely. Absolutely. From my interviews with many street artists and writers, what I have felt is that some of them are interested not in all the range of rights offered by copyright laws, just some bits of them, in the very same way as Creative Commons people or free software people are interested in some, in some rights which are offered. So I can see some comparison here. But I mean, what I also want to convey is that even many fine artists are just interested in some aspects of copyright. There are many fine artists that don't take action every time there is an imitation, right? So in my research, what I want to do is to try to demonstrate that there is no much gap between fine art or street art, fine art or graffiti, or at least that gap, if a gap has existed, is narrowing. And the 5 points case has played a role and is playing a role in narrowing that gap. My hope is that, and Judge Block, 72, 73, 75 years old, was very open-minded towards
83.
73, but was very open-minded about graffiti, right? In a very much way. I mean, he was more open-minded than the expert for Wolkoff, Professor Thompson.
Erin Thompson.
Yeah. Yes, I mean, she's a wonderful art historian, but she was very much focused on fine art. I mean, what Judge Block has done is to open it up, the Pandora box. Street art and graffiti is not anymore in a corner as a consequence of a 5 points decision. So my hope is that it will change the perception that many members of the general public still have. In my presentation, I talked about, my grandmother or, this kind of, but I mean, there are millions of grandmothers there still, thinking and believing that that's vandalism. Well, street art, let's be honest, street art is more appreciated than the graffiti writing, which I find, and not because I like very much lettering, of course, but so my mission is also to make people understand that lettering is a form of art. It's not easy, but the 5 point decision may help.
Mm-hmm.
Yeah, absolutely. Actually, Judge Block looked at every piece of evidence as art. He did not enter with a preconceived. At 83 years old, he was able to concentrate on the subject matter, the craft, and the tool used. And that's something he constantly spoke on and spoke about. He admits that he doesn't really understand lettering, but he was able to look at it as art and as a craft, and the scale was very impressive for him. The condition in which the art was created, the provenance obviously became 5 points, but he really looked at every piece individually as he would in any museum. No less, no more. He did not say, oh, this is graffiti, which we were lucky.
And I think if I may add, and this little bit connects to what Kathy also said in her presentation, I think he had a kind of a change of heart between the two decisions. And of course, it was because the works were destroyed. And I think this is also part of the power of destruction. Once you don't have them anymore, then you come to value them a little bit more than you used to value them when they were still available. It's like a work of a deceased artist almost that is valued more because he does not paint anymore, and in this case because they were destroyed. So this act also added some value in his eyes. Was my reading of the decisions.
I don't know if I agree with that. I think he felt hardly disappointed because when he left us before he put out his written decision, he said, I can't grant the injunction, but I have faith that both parties are going to have conversation outside of the court. I have faith that Mr. Wolkoff, you are aware you're sitting on wealth of art. I have faith that the artists are going to be open-minded enough. And I have faith that together you guys can come up to a decision and to a solution where you will be able to preserve without me getting involved. Mm-hmm. And he also was pressured because several affidavits were presented saying the landlord was facing millions of dollars in loss, like signed affidavit by contractors, by his attorneys, by his architect firm. Turned out none of it was true. So that made a big difference too, because he really, I think, felt I cannot consciously have someone lose over $100 million if I don't let him move with. And he was very upset. He said it. He said the vandals, the so-called vandals, acted with pose, elegance, and respect of the court. And the developer, the assumed same age as him, assumed respectable landowner, actually was threatened to be put in contempt 3 times during his testimony, and the marshals were being called in. Mm-hmm. So there was a contrast also, I think, in his views. And don't forget, in injunctions, there was really no time to really talk about stature. There was one expert, Erin Thompson, for the defense, who's an art crime professor who specializes in antiquity, who basically, her biggest argument was like, if academic does not recognize a piece in the case, they have no stature. And that was her entire angle during the injunction. And we didn't go piece by piece. There was no time. So I don't know if he glorified the value. I do feel he penalized the action because he's first and foremost a judge and he believes in the law. And he feels that the landlord willfully broke the law. To prevent artists in the future to go, how dare they go to court? How dare they drag me to court? It's my property. So there was a very punitive approach in his verdict and the way he wrote it.
Yes, thank you. It's very interesting to hear everything that happened and is not written in the decisions.
Mm-hmm.
Okay, since there's a pause, I'm going to jump in. And I don't know, panelists, if you're able to look at the chat and the platform, but there are so many nice compliments as well as really wonderful questions. So in the interest of time, I think I'm going to try to generalize some of them so that you have a chance to address some of the topics. So let me throw a few out and then let you jump into what you find interesting. One is setting up tension between First Amendment rights and moral rights. One is about, or there are several along these lines. Another question is on special concerns about the public nature of a lot of the art we're talking about. Does it make a difference that it's public art? Another is regarding the expressivity of destruction as an expressive act. Another is the importance of defining certain things as art for considerations of rights. And then there's a question about whether a time machine could be built and we could go back in time and follow the law in the 5 points case, how that would look and who would be satisfied with that. So I'll let you jump in and I'll continue to monitor the chat.
Okay, so I'll go with a time machine, I guess. I think the time machine had the whitewash not occurred and had the landlord given us written notice and our 90 days on the VARA. What I can tell you is we had a secret board and we had an army of people willing to help to remove. The building was going to be torn down, so there was very little restriction in what we could take and not take. It was a matter of time and energy. And the few pieces we were able to save that were not whitewashed, some of the pieces were on sidings, and it took a screwdriver, a ladder, and 3 people. So I think maybe we would have saved enough to fill a museum, or at least a wing of a museum. And even if it was not on display all of it today because we know this can take time. A lot of beautiful art are in basement and archives or museum and not necessarily on display right away. But we could have preserved, and we could have preserved pieces that were not even protected under VARA, because we had Child who passed away in 2010 and his last living piece was on 5 points. So there were a lot of pieces that meant a lot to the history of graffiti we could have saved. So I think that would have been our favored outcome. And could we give the awards back right now? And I think I speak for 21 artists when I say this, and definitely for Mears. If we could give back in a time machine, give that money back and get our piece, no doubt that's what we would have done.
Great. Anyone else?
I'm taking the one on destruction as expressive act. I think it's a good point, because in my encounters with the street artists and writers, of course, many of them, they show quite annoyance at property owners destroying possibly their artworks, and they praise the 5 points decision, the 5 points case. Many of them, they would have been ready also to take action if they have access to a lawyer, because this is one of the main obstacles for many artists. But I must say that some of the artists and writers, especially writers that I have interviewed, they didn't like the idea of taking action. Not many, Mary, but just a few of them, they didn't like the fact that, especially graffiti writers, relies on the law to try to preserve an art which is and still a part of the subculture considers ephemeral, provisional, temporary. So for a minority of especially writers, hardcore graffiti writers, the destruction, the death of their artwork is part of the game, is part of the life and then death of the art. And I respect that. So my argument, my point is that if there are instead artists and writers that do want to follow that path, to try to save it, to rely on the law, in my opinion, this does not corrupt the subculture. No. Because copyright is neutral, as I said before. It's not just a legal tool in the hands of greedy corporations. Not. Actually, it could be used against the greedy corporations, right? It's neutral. We color copyright with the color that we choose, right? But it's always, I think it's fair to acknowledge that there is a part of the subculture that does not like this avenue, this path, and we have to respect it, I think.
Of course. There was also a change of opinion when the case first started. I mean, obviously we're in that world every day and we see artists every day. When the case first started, it was not about money, it was about preservation. And a lot of artists were scared of the case and they were scared of the consequences with the topic which comes, oh, we're never going to be able to paint again because of you guys, because you're suing a building owner. That was, the first year you had a small group where they were like, you're going to destroy our ability to paint legally because no one is going to give us wool. That was back in 2013. First appeal and then Supreme Court denying, and now a big win. Now the whole consensus has changed, which to me is a little saddening, that because money is awarded and it's a final win, some of the same writers that were against it now are like, you were so right, go for it, thank God you did it. So it was weird too. The preservation attempt bothered intellectually a lot of writers. The punitive aspect of the case on a property owner, now they're comfortable with it and they love it.
Mm-hmm. And I can see too, the tension between moral rights and First Amendment rights, and there is. I think there is indeed can be a tension between free expression, right? A secondary artist or a secondary person wanting to use a piece of art to express that message, where under the Visual Artists' Rights Act in the U.S., right, the the mutilation, distortion of an original piece of art that harms the original artist's honor, reputation, is considered a violation of that artist's moral rights. And so there is that tension, and can be that tension where the secondary user destroys, distorts, right, as an expressive act to create a political, social, or cultural message. But in the US, I think, under Visual Artists' Rights Act, unlike moral rights in Europe, it is actually subject to fair use. It's subject to the 4 fair use factors, and can be excused under fair use. We haven't seen a case directly apply the 4-factor test of fair use to a violation of moral rights, but it's possible that we might in the future. And this sort of also goes into destruction as an expressive act, right? Enrico, your slides sort of showed that exact situation between Banksy and King Robo, right? That there was this communication, this expressive destruction of each other's works that really probably created an awesome public dialogue for people walking down Regent's Canal. Seeing that artwork updated, right, its relevancy continuously to be timely was an expression that could not have been achieved without the destruction of the original art. And another example was I showed a slide of Sam Durant's Scaffold, which was a large scale wood creation of a scaffold in Minneapolis. It was exhibited outside, and his intention was to bring awareness to the still the largest mass execution of Dakota warriors. I think it was 38 warriors that were hanged at the same time, and that was his intention. And yet, right, it ended up actually offending the Indigenous community, and ultimately, the scaffold was disassembled and buried in a secret site through ceremony. And he actually ultimately said that my message is louder. My message was expressed louder through this public dialogue and this public, destruction of my piece of art than it could have ever been had my piece just been sitting right in Minneapolis without as much context and expression. And so I do believe in the destruction as an expressive act, and as well as this tension between moral rights and First Amendment free expression rights as well.
Great. Katya and Tim, I want to give you a chance to chime in.
I'd like to come back to the easy tag on the canvas and on the shutters, because that's something I'm always fascinated with. There's a German train company which got stickers which they put on graffiti on trains, claiming graffiti is art, but not on trains. So apparently the surface makes all the difference.
Yep.
If you do oil painting on canvas, it is art. If you do it on cardboard, it might not be. I don't get that. And when it comes to graffiti, I kind of think asking if something is art might not even be the right question. I mean, claiming that something is not art is just a way of saying, I don't like it. And when was the last time you've seen somebody standing in front of a billboard, looking at it and saying, oh, that's not art? I think, to me, a lot of it is art, but it doesn't really matter.
If I may add, I think we're now also working on a project that is looking to democratize this idea of who has a right to participate, to be present in our public space. Do you have to be a recognized artist? Do you have to be just very wealthy and to have enough money to put your advertisements? Or maybe it should be a right that is, in this or another way, is accessible to anyone to put some message on our shared public space. Maybe it is art, for example, but we don't know it yet. Maybe only in 50 years, people will know it was art. It happens so often. Or maybe it is something that is extremely unpopular. Only 50 people will find it, will understand its message, and all the others will say, well, that's ugly and my grandmother doesn't like it. Yeah, so the question is if we cannot, in a way, democratize what we all see and what we all perceive, so that it is not only a very, very small group of, for example, people that have power in this way or another have access to the public space, to speak in the public space and being visible, being seen. And this connects a little bit also to the question of distraction, which I really like the idea of the powerful act of distraction. But the question is, who is there to destroy? Because if I see a clean wall, for example, and I destroy this cleanliness by painting a tag on it, this is also a powerful, expressive act of distraction, seen like that.
Yeah. I think we're going to be cut off now because the time is ended. I just want to really get in quickly my sincere gratitude to this wonderful panel. These were just terrific presentations, a wonderful conversation. We had a wonderful audience who prompted us with great questions. It was my delight to participate. So thank you all. And I want to encourage everybody to come back this afternoon to hear our second art law panel, which will highlight new voices and art law scholarship. So thank you all.
Thank you.
Thank you.
Thank you very much.
Thanks, everyone.
Bye.
Bye.